Hello everyone, I'm George from Ireland, so welcome back to my English Law channel. So I'm going to be looking at two different forms of co-ownership, the difference between law and equity, between the trustee and the beneficiaries. Because there are often situations when there's a married couple, they've got a matrimonial home, one of the spouses dies, the other one survives, and their children. So what's going to happen to the property? I mean, often the land is co-owned through a trust. When somebody owns property absolutely, the owner's legal title includes the beneficial ownership, and they also have the right to control that property to enjoy it in any way they wish. So there's one absolute title which gives the owner all sorts of rights, well, every conceivable right. When we say that, it's not unlimited because, of course, you can't build something without planning permission. If you want you're allowed to do whatever you want in as much as the law provides for that. But if you have trust, then the ownership is divided between the trustee, in whom the legal title is formally vested, and the beneficiary, who has a separate equitable interest. So under this system, the formal legal title and the beneficial ownership are separated. So sometimes there's the trustee who controls the property but doesn't get to benefit from it, because eventually the legal title isn't going along with the beneficial ownership. So there's equitable interest. That's for the beneficiary, as in the one for whom the trust is created to benefit that person, the beneficiary. So we know about the 1925 Law of Property Act, and it imposed a trust for sale in all situations of co-ownership. But this was simply to make conveyancing more straightforward and faster. So this caused a few headaches and a few anomalies. That was partly because it sometimes wasn't suitable for co-ownable ownership principles. They just weren't applicable in the proper sense. The doctrine of conversion, for example, which we've got rid of, and express trust for sale. So Talata, Trust of Sale and Appointments, Trust of Land and Appointments of Trustees Act 1996 took effect in 1997. Trust for sale have turned into trust of land. Co-ownership now takes effect through a trust of land. While many of the LPA 1925 provisions about co-ownership are still valid, Talata has introduced a number of significant reforms in this sphere. So let's look at the two different types of co-ownership. Co-ownership is whenever two or more persons are simultaneously entitled to the possession of the same piece of land. Now, in history, there were different types of co-ownership. Some people say there still are. Joint tenancy and tenancy in common are the two different main types that you find in private law. So there is a major distinction between them. So in joint tenancy, the joint tenants, they together own the entirety of the property. They don't have separate interests. So when one of them dies, his or her interest dies with that person. So after the penultimate owner dies, then the surviving joint tenant owns everything. It's jus accrescende, the right of survivorship. So co-ownership is an end, and it's the last man standing. He owns everything. So the joint tenant has no interest that he can pass on in his will, the ones who've died already. Because it's all been bequeathed to the last person surviving. So the survivor has an interest at the end of this tenancy, and he can then put it in his will, or she can put it in her will. So that person's the only beneficial owner, and the interest does not die with that person, and he can be a testator, or she can be a testator, and pass this on as a legacy to an heir. So joint tenancy, a few co-owners, but they all own the whole thing. They don't own separate shares, and they can't divide it up. The last one alive owns the whole lot. Tenancy as common is different. They all own separate shares, even if it's not spatially separated. So they all have a defined share of the property, right? It could be 20% each between 5 of them, but this is not tangible. So it's not divided as in there's a dividing line, a geographical barrier or anything. He owns that bedroom, she owns that bedroom, she owns the kitchen, and he owns the drawing room. No, they all own a lot of it. They can divide it financially if they were to sell it in shares. So they own a share of the whole, even though it's not a geographical share, it's a financial share. And they can get rid of this during their lifetime or when they die in their will. They can sell out, they can sell on to somebody else, things like that. They can pass it on to an heir. There's no right of survivorship in tenancy in common. So tenancy in common is undivided geographically, but it is divided financially. Tenants in common, similar to the joint tenants, have unity of possession. So each co-owner in tenancy in common owns the entire property, just like under joint tenancy. So apart from certain statutory provisions, which I shan't enter into now, any co-occupier has the right, if any co-occupier is able to exclude another co-occupier from part of the property, then this is not co-ownership because it's geographically divided. So remember, under joint tenancy or tenancy in common, they own the whole property, the whole piece of land, or the whole house, or whatever it is. Okay, so anyway, there's beneficial ownership. This shows that the person has the right to benefit from the property. For instance, in a simple co-ownership, if there's a single legal owner of a property, could be a house or could be a vehicle, for example. The person has absolute title. He's the former legal title. He also has the beneficial interest. So this person can manage the property through the legal title and enjoy its fruits through the beneficial title, driving the car, renting out the car, selling the car, whatever, and not just legally owning it. So this is an absolute title. The formal and beneficial interest are united in the same person. So, so they're two separate interests, but they can be in the same individual. Okay, so we can come back to this trust mechanism. So this is about division of ownership when you separate the legal and equitable title. So the legal title and trustees who manage the trust for the benefit of the beneficiaries. The beneficiaries, the equitable owners, and they're supposed to enjoy whatever is good coming from it, as in the advantage of being able to live in the house or any proceeds of sale, things like that. So beneficial ownership is under a simple trust. Is the legal owner is not the same as the equitable owner. So the equitable owners have the beneficial interests. We call them the beneficiaries. So beneficial ownership is often seen as synonymous as having an equitable interest through a trust of land. So let's look at how co-ownership can come about. Most houses in the UK are owned by two or more people, or two more adults in most cases, and usually they'll both contribute to it directly, paying the deposit, paying the mortgage and so on, or sometimes indirectly by paying the auxiliary costs, for example, bills, doing the childcare, renovating the house, other expenses of running the house. So it's a home, as in they can live in it, but it's also an investment they could sell it on and then realise its financial gain. So in these circumstances, the people are advised that they should regulate this co-ownership situation by having a formal express agreement, and that would spell out what rights and obligations each person has pertaining to the land, and they might have an express declaration of trust, and that would be in consonance with the provisos of the Law of Property Act 1925, Section 53, 1, point B, and then they'd sign it. However, most cohabitees don't do that. They don't formalise it. Often they're unmarried couples are living together and they're unwilling to consider the eventuality that their relationship should break down. Seems a bit too pessimistic. As Alexander Pope said, hope springs eternal in the human breast. So there's no express trust has been declared under the LPA. These things can arise informally, even by the people, the parties, not realising this is happening through their conduct. And this is usually pursuant to the LPA 1925, Section 53, point 2. So that exempts implied trust from the formalities required of an express trust. Furthermore, on top of the express trust, their equitable co-ownership can happen through applying principles of resulting trust, constructive trusts, or occasionally propriety estoppel. So you have to be aware that the relationship between constructive trust and proprietary estoppel is unclear, but I will come back to that in a later video. So resulting trust, this is one of the situations when it can come about. Someone contributes directly to buying the house, but he or she doesn't have the name on the title. This is a purchase in the name of the other. In that situation, there will be presumption that the person who's contributed financially has a beneficial interest in the land through resulting trust. How about constructive trust? Well, this is one example. There are different ways it can happen, but a common method is this. A person has contributed to buying the house, might be paying money into the mortgage or whatever, the deposit, or might be indirectly through other contributions, financial contributions and labour contributions to the household. And so he or she doesn't have his or her name, legal title. So the court sometimes say there was a common intention on the basis of contribution, and they'll look at other evidence. So this is a common intention constructive trust, and that's to distinguish it from other kinds of constructive trust. Resulting in constructive trust is something I'm going to come back to in a subsequent video. So it's vital here to realise the cohabitee's rights are calculated on the basis of their contributions. So there've been several suggestions for reforms in recent years, but I'll jump off that bridge if we come to it. So we're looking at co-ownership. We have to answer questions about this. It's quite problematic about how the legal and equitable positions are different here. So we know that in law, Arabella and Belinda are joint tenants, but in equity, Arabella could have 1/3 share, and Belinda could have a 2/3 share as tenants in common. Okay, so I'll come on in a subsequent video to the difference between joint tenancy and tenancy in common in more depth. Toodaloo.